Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this on the court.
Good afternoon and welcome to yet one more virtual oral argument in the First Court of Appeals. We'd hoped to be live by this point, but due to the Delta variant, we are still virtual. We have one case on today's docket. It is case number 0119008885CV, West Loop Hospitality LLC and Jedall Companies Inc. versus Houston Galleria Lodging Associates LLC. Would the attorney for the appellant make his appearance, please?
Your Honor, Joe Sibley for the appellants.
And for the appellees and cross appellants?
Good afternoon, Your Honor. This is Roger McCleary with Parsons McIntyre McCleary on behalf of appellees Raymond Management Company, Inc., the estate of C.J. Raymond and Barry Perkel.
My name is Rodney Drennan. I work with McCatherine Houston. I represent Houston Galleria Lodging Associates, LLC, the cross appellant.
Thank you. And it's my understanding today, because we have an appeal and a cross appeal, we have a slightly more complex setup of argument. But my understanding is that Mr. Sibley will go for 10 minutes, followed by 11 minutes by Mr. McCleary, followed by 2 minutes by Mr. Drennan, followed by 5 minutes by Mr. Sibley, followed by another 2 minutes by Mr. Drennan. Is that everybody's understanding?
Yes, Your Honor, it is.
Yes, Your Honor.
Yeah.
All right. Thank you. And Mr. Sibley, you may proceed as soon as the other attorneys are removed to the waiting room.
Thank you, Your Honor. May it please the court. This is a very complicated, procedurally complicated case because we have multiple interlocutory summary judgments, but we tried to make our appellate issues relatively straightforward. We raised 3 issues. The first is whether we were entitled to Chapter 38 attorney's fees in the trial court. The second was whether the trial court erred in dismissing our fraud claims. And the third was whether the trial court erred in dismissing Mr. Chowdhury's breach of fiduciary duty claims. I'm going to address the Chapter 38 issue, Your Honor, in conjunction with the cross appeal issue, because those are really, that's really the kind of the main event, I think, of this case. If they're right that we were not entitled to keep the earnest money under the contract, obviously that negates our Chapter 38 claim. And if we're right that we were entitled to keep the earnest money, that sort of nullifies their breach of contract claims and their Chapter 38 claims that they've asserted. So I want to talk first about the contract. I think the contract is pretty straightforward as far as what circumstances a party may, in this case, the appellees may obtain the return of their earnest money. There are 2 paragraphs in the contract that allow for that. Paragraph 3 very clearly says that it's non-refundable and it's subject to 2 conditional events that are found in, I believe it's section 9 and 18. The only one that's been raised here for our purposes is section 9. And really what that is it's an allowance for HGLA to raise an objection to an exception to a title policy that was issued by, I believe it was Independence Title Company. And if you look at what they claim is their objection that allowed them to recover that earnest money, it simply doesn't qualify under that paragraph. The undisputed evidence shows that what they objected to was not an exception to title insurance. It was a standard kind of boilerplate provision that basically stated, look, this doesn't indemnify anyone for any future claims subsequent to the issuance of title. And that was very—
Can I interrupt you, Counselor, for just a moment?
Yes, Your Honor.
So the way that I read section 9 here, I've got it pulled up on my screen in front of me. It says, in the event any exception shown on the title commitment shall substantially and materially interfere with buyer's development of a hotel on the property, buyer may object and on and on and on. It doesn't say in the event any exception to title insurance. It says any exception shown on the title commitment. So aren't we bound by, essentially the language that the parties chose here? It is an exception. It does appear on a document entitled title commitment. I mean, don't we have to go with, how the parties chose to phrase section 9?
I understand her honor's point on that, but I think title policy, I think it's the customary usage of that term is a policy that ensures title. And so the fact that there's an exception on the title commitment that simply belt and suspenders protects the title company against any misunderstanding by, in this case, the appellee, I don't think that would qualify. And if you look at the undisputed evidence on what that meant in that exception, basically what they wanted, that is the appellees, is not even legal. So I'm not sure how a standard issue title policy could contain a provision that would be void as a matter of law. That's point one. But even
okay, I had a couple of questions just to follow up on that. I understand your argument. I think it's a very interesting one. And I guess the first question that I had was, I saw the cases that you cited distinguishing between liability insurance versus title insurance, but I didn't see anything that expressly makes it illegal, like against some provision of the Texas code for this exception, or to not have this exception in there. And then my follow-up would be, it looks like under section 9, there's 2 options in the event there is an exception that interferes with development. And the options are either get rid of it, which you've said you can't do under Texas law, or the other option would be insure over it. So isn't there an alternative to getting rid of the exception here?
Well, there's another qualifying. Let's just say, for the sake of argument, Your Honor, that that this would qualify as something that could be objected to as a title exception. I think we did cite, and maybe there's not a statute per se or a code that we cited to that would indicate that would be illegal. I think it was testimony from witnesses, and the weight of that evidence is what it is. But let's just assume that we're wrong about that. The other qualifying phrase and I'm looking at section E here, or sorry, 9 here as well, is that it has to materially interfere with the development. So I think in order for that to apply, the appellee would have had to demonstrate some kind of evidence that whatever this complaint was did in fact substantially interfere with the development. And the undisputed evidence that we cited from the record is they hadn't done anything to start development. So if they hadn't even started development, how could they make the good faith claim that this was materially interfering with development that hadn't even been started? Or if hypothetically, if they had started it, how this would have affected it, right? Because otherwise,
does the contract specify that the development had to have started? I mean, if the flaw prevents development from even starting, that seemed like a substantial material adverse impact. And that's what I meant, Your Honor, to answer his Honor's question. The answer is no. It doesn't say that development has to have started in order for there to be an objection. But I think I was alluding to this a little bit in what I just said, which is hypothetically, I guess I can understand a situation where this exception has impeded our ability to even get off the ground. Okay. I mean, I can see how that could happen, but there's no evidence that in fact occurred, right? The summary judgment evidence doesn't indicate that the reason why the appellee did not start the hotel development was because of this exception, right? So they would have to show that the exception that they're complaining of that qualifies under section 9 was the cause in fact of why it couldn't be developed, because that is the qualifying language in section 9. It has to materially affect the ability of the appellee to develop this property, and I think it's pretty clear that there's no evidence.
Let me ask the question, but couldn't that affect their ability to get financing or investors if you've got this possibility that after the contract for deed is signed, that these things could happen before title actually changes hand at the end of the road? I mean, wouldn't that be a problem if this could exist to bring in other investors or whatnot to their development of the project?
I think, again, Your Honor, hypothetically, theoretically, I can see how that could happen. I guess the question is, I think it was their burden to elicit evidence in summary judgment that that was in fact the case, because I agree with the court's points on the fact that it hadn't started development is not necessarily dispositive of whether this could have been a title exception that prevented development. The problem is this is only hypothetical and there's no evidence that that was in fact the case. In fact, the summary judgment evidence, the evidence you cited in the record, is that they never even created a private placement memorandum to generate investors. So to his Honor's point, if there was some evidence where, for example, they had generated a private placement memorandum and there was some evidence that investors were deterred from this investment because of this title exception, then I can see how they would have an argument that, hey, look, the lack of development wasn't our fault because this title exception, it kept us grounded. We couldn't get off the ground. But as it stands right now, this is just kind of a gotcha. I mean, it's just a kind of after the fact, hey, we made this objection to a title exception, and so we should get our earnest money back. But it's got to be more than that. They've got to show a causal nexus between the title exception and why it is that they were not able to develop the hotel. I think that's the only way you can read Section 9, Your Honor. And so if we're right about that, then Judge Shadwick made the correct ruling that we were entitled to retain the earnest money. And so then the question becomes, what about these Chapter 38 attorney's fees? I think the law is pretty clear that any benefit obtained from a breach of contract claim qualifies a party for Chapter 38 attorney's fees, even if it's the case that the Chapter 38 claim was a sort of compulsory counterclaim that defeated the other party's right to recovery, which in this case would be their claim that we're supposed to return the earnest money. The fact that the money didn't change hands is not a dispositive issue of whether we are a prevailing party for purposes of Chapter 38.
But aren't you just successfully defending that claim? And isn't there first Court of Appeals authority that says if that's what the nature of the Chapter 38 claim is, a successful defense, that you're not entitled to those damages under Chapter 38?
I'm not aware of which specific cases Honor is referring to. I know we cited some cases in our brief. I can pull them up real quick, but my understanding is that, well, this is actually now Plastics, it's a Supreme Court case, but if a defendant brings a counterclaim for a breach of contract where it arises from the same transaction or occurrence as the plaintiff, and in this case, the appellees were the plaintiff, then we're entitled to Chapter 38 attorney's fees. There's also authority that says, any benefits, any pecuniary gain or for example, even specific performance, for example, can qualify one for Chapter 38 attorney's fees. So I'd have to look at the specific cases Honor's referring to. I'm not aware of any authority that disallows our right to recovery of Chapter 38 here, but I'm just not aware of that authority, Your Honor. But the other argument that was made here, it's this thing that I think the legislature is looking at right now when it comes to Chapter 38, which is a lot of people are not aware of this, but it's an issue, which is that technically Chapter 38, the statutory language says you can only recover Chapter 38 fees from a person or a corporate, or defined basically as a person or corporation. Now, it is the case that the party we're seeking recovery of attorney's fees from is not a person or a corporation, and LLCs have been specifically held not to qualify under Chapter 38. But Your Honor, our argument is that wasn't raised in summary judgment. It wasn't raised in the trial court, and they're not allowed to raise that on appeal. Now, I guess the sort of practical judicial economy argument might be, well, why should we run this fool's errand to allow, for us to recover Chapter 38 fees if it's just going to be remanded, and we'll raise the argument there. But I don't think that would be appropriate anyway. But our argument is going to be in the trial court that, look, this is now the law of the case. We've already had an appeal on this, and you don't get to raise this. You don't get a second bite at the apple once it's remanded. And whatever the merits of that, it is what it is. But I don't think that's a valid argument this court to not to reverse the summary judgment on that particular issue.
All right,
I
thank
believe
you.
that statute's been amended, hasn't it?
I believe it has, Your Honor, but my suspicion is it's most likely not going to be retroactive in application, but I'm not certain of that.
Any other questions from the panel? No further questions. Okay. Mr. McCleary and Mr. Drennan, you get an extra 2 minutes. So we'll give each of you 1 extra minute to argue. So it'll be 12 minutes for Mr. McCleary and 3 minutes for Mr. Drennan.
Thank you, Your Honor. May it please the court. I will be addressing Appleby's points, and specifically I want to dive into the arguments we've heard about Westloop's claim for attorney's fees under Chapter 38. Justice Kelly, you're correct. That statute has been amended. It's not retroactive. The statute that was in effect at the time did not allow an award of attorney's fees against an LLC. By the way, this is an additional ground in support of the issue we raised below, that they're not entitled to attorney's fees. And so it's something we did raise and preserve in our briefing, and it's properly before this court. With respect to their claim for Chapter 38 attorney's fees, the court's ruling below should be upheld for 3 reasons. First of all, WLH or Westloop Hospitality, prove a valid breach of contract claim and obtain an award of damages as required by Chapter 38, which is the only basis on which they sought attorney's fees and argued for it. They did not obtain any injunctive relief or a judgment for specific performance. And then finally, Chapter 38 does not authorize recovery of attorney's fees against an LLC, at least the one that was in effect relating to this matter. With respect to damages, the Butler case stands for the proposition that reasonable attorney's fees can be recovered in addition to the amount of a valid claim. And the opposing counsel wasn't sure what case stood for the proposition that you couldn't recover attorney's fees for pure defense of a claim. That was addressed in the Green International Inc. case versus Solis, cited in our briefing. It's a Texas Supreme Court case that held to recover attorney's fees under Chapter 38, a party must first prevail on a cause of action for which attorney's fees are recoverable, and second, recover damages. That didn't happen here. The appellants did not recover damages. And they tried to bootstrap in this theory that, well, gee, attorney's fees are recoverable when there's a counterclaim that is defended, and the counterclaim arises from the same transaction and same facts required to assert the original claim. That argument is a red herring because it still requires a valid claim for relief under the Green case. It still requires an award of damages, certainly at least something of pecuniary value, as the case law contemplates. They rely on the Brokey case and the Smith case for this proposition. Both of those cases, again, required still a valid affirmative claim for relief with damages, which was not awarded here to the appellants. Those cases also, then subject to having that valid claim with damages, required indistinguishable facts in defending against the counterclaim. The facts here are certainly distinguishable. The appellant's claim for breach of contract was simply that HGLA breached the contract, the purchase agreement, by not making the first payment of $3 million. That's the extent of it. It's in their pleading, Courts Records 3235. They also asked for an award of $3 million, the first payment. They didn't get it. They were not awarded earnest money, contrary to what they assert. They cite no authority for the proposition that simply keeping the earnest money or negotiation fee that they already had is somehow awarding damages. No authority whatsoever.
Well, I had a question about this. I was just thinking as I was reading both of your briefings, surely this is not the first time that this situation has come up, where somebody, was just trying to hang on to the earnest money and files a breach of contract claim and tries to get their attorney's fees. Did you come across any cases that address this specific scenario?
Not this specific scenario, Justice Ferris. I did not. But certainly cases that stood for the proposition that you had to have damages, or as I'm going to segue into, let me just make my point that the claims that HDLA asserted in their counterclaim were far different and more extensive, and certainly were not indistinguishable from the claim asserted by Jital for failure to pay the $3 million. We had claims insisting that they breached by encumbering the property with the deed of trust, which, by the way, I think the court properly observed, there's nothing in the contract at risk of stepping on Mr. Grennan's toes that required HDLA to do a thing to develop this property before the contract closing date. That's just made up out of whole cloth by opposing counsel. The HDLA's breach of contract claim also included a claim about their failure to provide and indicating and taking the position that they would not provide a perpetual easement to access Westheimer, which is a critical factor for HDLA, and also they didn't have fee title to the 2425 property through which the easement was going to be provided and the parking lease was supposed to be provided, and failing to identify legal proceedings regarding Jital. So the Brokey and Smith cases are not applicable or opposite to this case.
Give me a second,
They didn't
Mr. McCleary. Those are also some of your fraud claims, are they not? The failure to provide the easement, the fee title claim, and the lawsuits.
Yes, they are, Justice Hightower, and those are also specific provisions included in the purchase agreement. That's the distinction. Our fraud claims are based on representations that were also incorporated into the purchase agreement.
I had a question, a follow-up on that. When were the representations that the fraudulent inducement claim is based on, when were those originally made? I know they're incorporated into the contract itself. Is there testimony in the record about when those first came up, when your client first heard those representations?
Justice Ferris, I can't cite you to a specific reference. As I recall, there is evidence in the record concerning the initial discussions or the discussions with Mr. Chowdhury before the purchase agreement was signed. I believe Mr. Brickell talked about that during his deposition. And then, of course, they are specifically stated and again included in the purchase agreement.
Sure.
Then to go on, appellants are wrong to claim that they're entitled to recover attorney's fees even though they didn't recover any damages. They rely on the Butler case and they rely also on the Rasmussen case. Both of those cases involved an award of some other relief. The Butler case involved an award of an injunction in a covenant not to compete case, and the Rasmussen case was a arbitration related case, and there was an award of specific performance of arbitration in the case. So they're not apposite. They also rely on McKinley, Imperial Lofts, Taylor Electric, and Matthews. Those cases are not apposite. They dealt with offset issues, and this is not a case where we had to offset awards. They didn't get an award, so they're not applicable. And then lastly, as I indicated before, Chapter 38 didn't authorize recovery of fees against limited liability company like HGLA. With respect to appellant's fraud claims, the court should overrule appellant's issue on fraud and affirm the summary judgment dismissing appellant's fraud claims for three reasons. First, the economic loss rules bars their post-agreement, the post-purchase agreement claims. The purchase agreement's merger and disclaimer of reliance provisions prevent appellants from being able to prove reliance element of their claims as a matter of law. And then finally, they haven't met their burden at all as parties resisting any no evidence summary judgment against their fraud claims to raise a genuine issue on those claims. With respect to the economic loss rule, the court, I'm sure, is familiar. It precludes recovery in tort for economic losses resulting from a party's failure to perform under a contract when the harm consists only of the economic loss of a contractual expectancy, as addressed in the Chapman Custom Homes case. There's an exception. The economic loss rule doesn't apply to fraudulent inducement claims under Formosa Plastics. However, this court, in the classical Vacations versus Air France case, declined to extend Formosa Plastics to include fraud that occurs after formation of the contract and that results only in loss to the subject of the contract. And that's what we have here with respect to their fraud claims regarding the failure to make the first payment. Those are not pre-contractual fraudulent inducement claims, so they're not subject to the fraudulent inducement exception under Formosa to the economic loss rule. They claim that their pleading says in paragraph 21 of their counterclaim, court's record 3234, that they relied on counter-defendants' promises and assurance that they would tender the first payment. And this is after the agreement was already entered into, so they're post-contractual claims. And their alleged losses are of contractual expectancies, so their claims are barred by the economic loss rule with respect to the first payment. With respect to the pre-contract representations regarding the alleged partnership, it's not stated in the purchase agreement. The contract includes a disclaimer in paragraph 24 that clearly and unequivocally disclaimed reliance on representations not expressed in the purchase agreement. The purchase agreement talks about an LLC. It doesn't talk about a partnership. The language in the purchase agreement is completely inconsistent with the allegations of partnership in this case, and the provisions in paragraph 24 clearly disclaim reliance on any representations not in the agreement. Additionally, the circumstances that are to be considered in enforcing a disclaimer agreement like paragraph 24 are all met here. They're addressed in the Forest Oil case. The 5 factors, there's evidence that the terms of the contract were negotiated. The parties were represented by counsel. The sellers represented by Merwin. All the appellants were represented by Merwin. There's evidence that there was an arm's length transaction. Again, they were represented by Merwin, and they agreed in the purchase agreement that the buyer and seller were experienced in transactions of the nature provided for in the agreement. Clearly, the parties were all knowledgeable. There's evidence of that. It's also referenced in the purchase agreement, and the disclaimer language itself is very clear. They've also offered no evidence to support, to contradict our summary judgment on no evidence grounds of this fraud claims. And they failed to address that in their briefing to raise evidence in response to our summary judgment, no evidence on the fraud claims. So the dismissal of those claims should be affirmed.
Are there any further questions from the panel? Since there are no further questions and your time has expired, we'll now turn it over to Mr. Drennan.
Thank you, Justice Kelly. May I please the court? Again, my name is Rodney Drennan. I represent HGLA. I'm going to be very, very brief. This was a hard-fought and very, very complicated case. However, at the very end, we were prepared to go to trial on breach of contract actions, and summary judgment was granted against my client. And my summary judgment claims, or my client's summary judgment claims, were then denied. The court made a mistake there. There was uncontroverted evidence that this court should reverse the summary judgment denying HGLA's breach of contract claim and render judgment for HGLA. It is uncontroverted that there was a valid agreement. It was the purchase agreement that HGLA performed when it paid the $750,000 second payment on time. And then it is undisputed that Jedall, or the subsequent assignee West Loop, repudiated or breached that contract almost immediately. They insisted that they could and would encumber the property with a deed of trust before the closing.
Could I interrupt you, counsel? I just had a couple of questions with respect to how your fraud and your contract claims interact here. It's my understanding that they seek the same damages, right? The return of the earnest money and negotiation fee.
Yes, and Justice Ferris, I want to be very clear here. It's a fraud in the inducement claim.
Yes,
not
fraud and
a
inducement,
fraud
yes.
claim. That makes a big difference in this particular.
Yes, under the economic loss rule, it does.
Okay.
But they seek the same relief. That's correct.
They do.
Okay.
Of course, we would obviously opt for punitive damages, and it also provides us with a certain other issues with regard to certain damages. But yes, in essence, the underlying damages are the same, but under From Western Plastics, we're permitted to do so. And we can elect which theory we want to recover on after the trial. And sadly, we didn't get a trial. And that's what we're here for today.
And did y'all appeal in your briefing here? Have you appealed the denial of the punitive damages element as well?
Yes, because we basically all of it, because we didn't get a chance to even present the punitive damage element of it.
Sure.
They were granted summary judgment on that issue, meaning that the court said everybody's fraud claims goes away, and we were set to go to trial on the breach of contract claim. And at the last hour, a 166G motion was filed, and then suddenly the judge said there was no triable issues of fact. And I wholeheartedly, with all due respect to him, disagree. It is uncontroverted. Even their own attorney said, and this was Merwin, stated that they could not and would not provide the access through 2425, which was absolutely a part of the contract. He specifically said that Jedal owned 2425. They did not. It just goes on and on and on. I would like this court, and I'm going to have a couple more minutes here in a minute, but I would like them to reverse and render. I don't think that there is any evidence that contradicts our motion for summary judgment on liability and damages with regard to at least the breach of contract issues, and that it should be tried on the fraudulent inducement issues. Thank you.
Thank you, Mr. Drennan. Mr. Sibley, you have 5 minutes.
Thank you, Your Honor. I first want to address this issue of whether we're entitled to Chapter 38 fees, because what I keep hearing is, well, all you did was defend the claim and you didn't have an affirmative claim. That's absolutely not true. If you look at tab F to our opening brief, we have our live pleading. And if you look at paragraph 27 under breach of contract, we very clearly pleaded that the appellee HCLA breached the contract by failing to tender the first payment, and that we're entitled to liquidated damages in the amount of the negotiation fee, the earnest money, and the first payment totaling $4 million. Now, the fact that we only wound up with $1 million doesn't mean that we didn't have an affirmative claim for relief. For maybe we didn't get everything we asked for, but we definitely got something. We got a 25% of what we asked for. And tab D to our brief is one of the orders on summary judgment, which very clearly says, I'm sorry, it's tab C, my mistake. Tab C very clearly says that it is ordered, adjudged, and decreed that our damages are limited to retention of the earnest money. So we did have an affirmative claim for relief. There was a finding that we were entitled to damages. It's only that finding was that under the contract, we're limited to the $1 million. We're not contesting that on appeal. So it's just simply not true that we did not have an affirmative claim for relief, that we ultimately obtained relief, which was that we're limited to the $1 million that we had, even though there was no, changing of hands per se, or an award of damages that caused them to have to pay us. The second issue is, I've heard from opposing counsel a lot about these supposed misdeeds of Jatal and other appellants, but what I haven't heard is any evidence, and this is key, any evidence that under Section 9 that they presented evidence that, and this is the actual language from Section 9, that whatever the problem is with the exception to title commitment, that it substantially and materially interferes with the buyer's development. There's no evidence of that. And if they don't have evidence of that, and they didn't present it in the summary judgment record, then they're out. There's no other way they have an entitlement to recovery of the earnest money, because that's the only way they can get there. So all of these other claims about, well, they were going to do this and they were going to do that, first of all, that specifically the four corners of the contract doesn't give an allowance for that. And secondly, these were all hypothetical issues that even if they had come to a head, Section 9 also gives Jital, who ultimately became the successor in interest in this contract, gives Jital the ability to cure those. And so if we don't have a ripe objection and a ripe issue, how could we ever cure it or address, those issues under Section 9? So that's pretty much all I've got, Your Honor. I think that's the critical issue in the case is, have they presented any evidence that whatever this title issue is, whatever these complaints are, substantially and materially interfered with the development of a hotel on the property? And I think the answer is clearly no.
Are there any questions from the panel?
No.
Thank you for your argument, Mr. Sibley. Now I'll return to Mr. Drennan for 2 minutes.
Thank you again, Your Honors. It comes down to the summation. It comes down to this. My clients attempted to buy a property from an individual who didn't own a property, who said he could own it and who never did. He claimed that he could provide parking and access through a building that he owned that he didn't. And then he claims that he is a partner in a partnership that has never existed, and that somehow he's lost millions of dollars because my clients could not develop a piece of property that he didn't own and he couldn't sell them. I mean, that just by using common sense negates Jital's and WCW's, all of their claims.
Let me ask a question. In regard to the easement and the parking agreement you're talking about that Jital didn't own, but didn't a company own it that Mr. Jital was a principal in or involved owner of, this 2425? Isn't that who did own the easement in the parking garage?
Yeah, it's interesting that you mentioned that, Justice, is that he actually owned a limited partnership, or he was, I believe, the general partner of a limited partnership that owned the entity. But the problem was he was in litigation at the time with one of the limited partners, and that limited partner would not give consent going forward. In fact, we asked for a subordination agreement. This is all over the record. We asked for a subordination agreement where I asked straight up, Mr. Merwin, can you give us the perpetual easement and can you give us a lease for a long term? Our fear was if 2425 was foreclosed upon, as you know, under Texas law, the foreclosure would immediately terminate the lease. That would destroy our ability to go ahead and develop the property. That's exactly what that hindrance in development.
Would that made you have then needed some type of approval or subordination from the agreement from the lender of 2425 as well?
Exactly, and they refused to give it. And so the issue that it came down to was he couldn't provide exactly what he stated he could provide, i.e. fraud and the inducement. And the other part of it is that he could not provide the subordination, meaning that they couldn't guarantee that we would have a perpetual easement and we would have basically long-term leasing for parking spaces. You can't develop a hotel without access and parking. And so that is prima facie evidence of the lack of ability to develop, exactly because they couldn't give us the title policy that we wanted to get. Thank you very much. Always good to argue in front of you, and I appreciate all of your questions.
Thank you very much, Mr. Drennan. Cause number 0119008885-CV is submitted, and the First Court of Appeals is virtually adjourned. Thank you all, counsel.